Well, there is still no word from a state lawmaker on whether she will resign after a felony conviction. Friday, a jury found DFL Senator Nicole Mitchell guilty of burglary and guilty of possessing burglary tools for breaking into her stepmother's home last year. Currently, Democrats hold a one-seat majority in the Senate. Mitchell's case and the case of Vance Boelter, accused of murdering Representative Melissa Hortman, her husband Mark Hortman, and the shootings of Senator John Hoffman and his wife Yvette, are cases we are going to break down right now with criminal defense attorney Joe Tamburino. And Joe is joining us now. Thank you so much for coming on.
Thanks for having me on, Esme.
All right. Want to ask you first about the Nicole Mitchell case. Her attorney said after the guilty verdicts that they were going to fight to make sure that she did not end up going to jail. That conviction faces a mandatory minimum of 180 days in jail. Can you get out of that?
No, it's almost impossible to get out of that. What the statute says is very clear. If you're convicted of first-degree burglary under the provision that she was convicted of, which means no prison, but you do have to serve a minimum of 180 days in local time, you can get work release. Now, a judge can depart from that, but it's almost impossible to get that.
Okay, so work release could be considered as part of that.
Work release is basically if you have a job, yes, you can leave the custodial facility and go to work and come back in the evening. So she would be eligible for that if she has a job.
Her attorneys also said that there had been plea bargain talks in her case, but that she was the one who ultimately decided not to take the plea bargain. Do you think that she should have taken the plea bargain?
Yes, this case should have been resolved early on. Now, my understanding is that the prosecutor did not offer what's called a misdemeanor trespass. However, under Minnesota law, there are 4 degrees of burglary. The 4th degree is the least severe. It's not even a felony, it's a gross misdemeanor. I would have imagined what could have been a good plea bargain in this case for both the state and the defense early on would have been something like this, that she would have resigned, she would have apologized, done some community work service, paid restitution, but she could receive a 4th degree burglary, which is a gross misdemeanor, not a felony. That would have saved everyone a lot of heartache and time and trial. I think that would have been an appropriate plea bargain at the very beginning of this case.
Interesting. All right. I want to ask you about Vance Boelter. Of course, he is accused of murdering Representative Melissa Hortman, her husband Mark, and also the horrible shootings of Senator Hoffman and his wife. It looks increasingly like the federal government is going to pursue the death penalty. 2 things happened last week that I want to ask you about that seem to point to that. One is in the new indictment released on page 5. The headline is Notice of Special Findings. What does that mean?
Well, when the federal government wants to get the death penalty on a defendant, they have to go to a grand jury and get these special findings. And you're quite right. In this new indictment on pages 5, 6, and 7, there are a list, a number of special findings. And what that does is it gives then the Attorney General of the United States, Ms. Bondi, the opportunity and the authority to say, in this case, I want to go for the death penalty. So the grand jury doesn't make the decision of death penalty or not. What the grand jury does is says, yes, in this case, there are special findings, and then the Attorney General uses that to seek the death penalty.
Because ultimately it will be Pam Bondi's decision. Another development happened late Friday where a filing showed that a public defender has been assigned to Vance Boelter, who is a specialist in death penalty cases, and she works actually out of Nevada, so she'd have to come here for the trial. What does that say to you?
Well, that says that it's likely Ms. Bondi is going to ask for the death penalty in this case. And that kind of practice in the federal system is very common. You see, here in Minnesota, we don't have the death penalty. Our last execution was in 1906, and it was outlawed in 1911. However, under federal law, you could still get the death penalty, but it's never happened in Minnesota. So really, we don't have a lot of attorneys, if any, who are schooled, knowledgeable, and experienced in death penalty cases, specifically on the federal level. So it's quite common to bring in extra help, public defenders from different federal districts who do have experience in death penalty cases.
There's a lot of talk or discussion about possibly Boelter taking some kind of mental illness defense. Is that a possibility? Do you think he would qualify for that kind of a defense? Clearly, he does not seem to be in the right mind. But on the other hand, the planning, the alleged planning for this was just meticulous.
Yes, I think it would be very difficult to prove a mental illness defense. And here's why. I think we all can remember that back in 1981, President Reagan at the time was shot by John Hinckley. Back then, the mental illness defense in federal court was pretty favorable to the defendant. But in a matter of 3 years, the federal government changed the law on that. And ever since then, since basically 1984, it's a tough standard to meet. Right. Now, Mr. Boelter would have to not only show that he was under such mental defect that he didn't know what he was doing, didn't know the nature of his acts, but he'd have to prove it by clear and convincing evidence. The burden would be on him. It's one of those few areas of criminal law where the burden is on the defendant. I think that would be extremely difficult to do in this case, considering all the surrounding circumstances.
Right. Joe Tamburino, always a pleasure. Thank you so much for helping us sort out these cases.
Thanks for having me on.